Our next topic is Inventive step at the UPC, and we will ask whether there is a recent shift towards EPO practice. I think there is a lot of shifting these days. I mean, probably all of you have read about G1 out of 24, decision of the enlarged Board of Appeal of the EPO, and there we found actually a very nice shift of the EPO, the enlarged Board of Appeal, towards UPC practice, namely insofar as for claim interpretation, you have always look into the description and figures. This is actually established practice at the UPC. It was, there was divergent case law in front of the EPO, and now we have clarity across Europe, I would say. But this is not the actual topic. It's only another example for another shift here for the EPO towards the UPC. Now to a potential shift towards EPO practice from the UPC. By the way, my aperitivo today is a Munich beer. It's alcohol-free because we have roughly 30 degrees Celsius and it feels like 200, humidity of 200% or so. So it's much too hot for anything else. It's an alcohol-free and very tasty Munich beer. So now to the recent shift. Let's start with the old days, not so old days. In 2023, the Central Division Paris has firstly mentioned the problem-solution approach. We are well aware of the problem-solution approach, of course, from the EPO practice. But however, they said that this panel is aware that in order to assess the inventive step challenge, the EPO and some national jurisdictions apply the so-called problem-solution approach. This test is not explicitly provided for in the EPC and therefore does not appear to be mandatory. And then they said bluntly, regardless, applying the problem-solution approach to the present proceedings would not lead to a different conclusion. This was insofar interesting because they actually did not apply the problem-solution approach. They just said, well, it would be the same. We don't know how they came to that conclusion. Then, some considerable time later, this was, I think, in roughly October 2024, a very famous decision from the Hague division, local division in The Hague. Why is it so famous? Because it was the first decision actually considering in depth equivalent patent infringement and also confirming equivalent patent infringement. But here it's about inventive step, also very interesting. It's the first decision, as far as I know, that used only the problem solution approach. They said an object approach must be taken to the assessment of inventive step, and that the subjective ideas of the applicant or inventor are irrelevant, and inventive step is to be assessed from the point of view of the skilled person, the basis of the state of the art as a whole, including the skilled person's common general knowledge. And they said, in order to assess whether or not a claimed invention was obvious to a skilled person, the court will follow the problem and solution approach as suggested by the parties and as also used by the EPO as a tool to assess obviousness. In this context, it would be necessary to determine a realistic starting point. It's important realistic starting point in the state of the art. So they do not mention the terminology closest prior art. They mention realistic starting point. And one of our first UPC aperitivos, I think it was Mario, who taught us about the inventive step doctrine at that time. And this formulation or wording, realistic starting point, is very old actually within the UPC practice. Here, the Hague division said also there has to be a justification as to why the skilled person would consider a particular document in the state of the art as a realistic starting point. So again, realistic starting point, not the closest prior art. So this was more or less expected from the Netherlands, or I and I think many others did expect this, because also here the Netherlands have a long tradition of using the problem solution approach. So however, in very recent times, in spring this year, also the Munich local division, so one of the 4 German local divisions, supported the problem solution approach, even in a head note decision. The second head note, they said, for assessing whether invention shall be considered obvious, having regard to the state of the art, the problem solution approach developed by the European Patent Office, now it comes, shall primarily be applied as a tool to the extent feasible to enhance legal certainty and further align the jurisprudence of the Unified Patent Court with the jurisprudence of the European Patent Office and the Boards of Appeal. I find very interesting this terminology shall, actually. I mean, they didn't even say should or could or whatsoever. They said shall primarily. And why they believe they can come to such conclusion. First, they said in the reasons, well, considering, for example, the German tests, we believe that both tests, the German test and the problem solution approach, if correctly applied, should lead to the same results in the majority of the cases. And both tests require a realistic starting point and an incentive for the skilled person to do the next step. So again, here's the realistic starting point. At one occasion within a decision, they mentioned even that terminology closes prior art, but I don't think that they mean here that there's only one closest prior art. I think they are in line with the division in The Hague and also German practice, where it is sufficient and also mandatory to find a realistic starting point. Can be several of them. Further, they argued, well, the general objective of the UPC is to harmonize things, and we need also legal certainty for both the users of the system and the various divisions of the Unified Patent Court across Europe. And they believe that applying the problem solution approach further aligns the jurisprudence of the Unified Patent Court with the jurisprudence of the EPO and the Board of Appeal of the EPO. So this was actually an important argument for the local division in Munich, that they said, well, there's a primary objective of the whole system to harmonize things. And the other body of harmonization, of course, in Europe is the European Patent Office. And therefore, we want to converge with them and not diverge from them. So how is the perspective of the Boards of Appeal of the EPO actually recently? I found a decision notified in March this year, 2554 out of 22, where some interesting guidance from the Board of Appeal can be found. I mean, the Boards of Appeal have never, in my opinion at least, never strictly applied the problem solution approach in a way that there can be only one closest prior art. But very often it was very cumbersome to convince specifically the first instance authorities, but sometimes also the Boards of Appeal, that there can be a third or fourth attack on inventive step, but based on a third or fourth primary prior art. However, in that case, the board did not deny that several close prior art documents may exist. So not closest, but close prior art documents. A skilled person may have used any of them as a starting point, and it may be necessary to assess inventive step from multiple angles. However, in the present case, a skilled person addressing the problem and so on would not have started from D1, but from D7. In this sense, they said, in the present situation, D1 is not a realistic starting point. So two interesting things. They also use the terminology realistic starting point. And they are not using actually the terminology closest prior art. They say, well, several close prior art documents may exist. Is this now the end of the route? No, it's not. In last month, so roughly 5 weeks ago, I found a decision of the Düsseldorf local division without any sign or any glimpse of the problem solution approach. They said, roughly in terms of inventive step, the subject matter of the claim may be obvious if the skilled person would have been motivated to implement it as the next step in the view of the problem. A motivation to implement may be absent or negated if the skilled person is faced with many uncertainties or expected difficulties. If there is no motivation at all or a negated motivation, the subject matter of the claim is not obvious and it involves an inventive step. So I think basically we can agree with this. Personally, I have difficulties with the last sentence. They say if there's no motivation at all or even a negated motivation, the subject matter of the claim is not obvious and it involves an inventive step, as if this would be always the case. But I don't think this is always the case. I think very often in mechanical cases, in the very least, you have a so-called invention without any advantage, any effect. And then, of course, you usually will have troubles to find any motivation or incentive in the prior art, because there will be no source of the prior art saying, well, incorporate feature X in order to achieve effect Y or advantage Z or whatsoever. So in those cases, it's very rare or basically impossible to find a clear motivation for doing nothing specifically advantageous. Even further, if you think about this, this would mean that, yeah, well, if there is no advantage, and you probably won't find a motivation to do it because no one will say, do it because it's advantageous, then the likelihood for inventive step would be higher, or it would be more easy at least to argue for inventive step. I don't think this can be the conclusion. So I assume they mean here, yeah, well, if there is, as we might expect, an advantage or effect of the invention, then we need a motivation in order to confirm obviousness. So, and you can also find this, by the way, in the first case, or in a decision of the first case of the Central Division in Munich, in the 6th head note, and I think this is the correct way of analyzing it. In the 6th head note, they said a technical effect or advantage achieved by the claim subject matter compared to the prior art may be an indication for inventive step. And now, a feature that is selected in an arbitrary way out of several possibilities cannot generally contribute to inventive step. I think this is the correct approach, and I very much hope so that the local division Düsseldorf actually means this when they say, well, we always need a motivation. I think, yeah, well, if there is a technical effect. So this is the end of our chapter in relation to inventive step. Thank you.